Okay, can you circulate the
You always use it for the. I thought it was cool. I thought it was a cool intro. Almost as cool as that Jack. No, just too late. But yeah. You already know.
Monuments text not reasonable procedure reflect the wishes of the policy. There you
I
go.
thought somebody was playing music down there. You realize everyone's familiar, yes, a reasonable observer, understanding.
Whatever was this one? Private service.
You know what I did see? He did use No. He didn't do it a lot. You know, we were always on the lookout for LY words.
He cited a website. Gallery. That's weird.
Maybe it's
Yeah, it's a picture. That's funny. I've never seen anybody cite a website.
See, there was one. Dang it! I wrote down the page somewhere. I think in my email.
What are you looking for?
He said seriously, and then he used petitioner a lot, which is nice.
Do they get to see each other's briefs or something? Like, how does he mention the petitioner's brief?
Yeah, ask.
Professor Walker. Does he like get to see the other person's brief?
What'd you say?
Like, how can he reference what the other
He's
guy's
talking
like
about
going to
the
talk
petitioner
about?
brief. No, some of these
So
are different.
let's see. I'm not sure if he was the petitioner or the respondent. If he was the respondent, the other petitioner already filed it.
And he saw it.
What'd you say?
Can we see it?
Yeah.
Oh.
And then, so what happens is, let's say you file an appeal. You file a brief. And then your opponent sees your brief, along with the whole world. It's a public record. And then your opponent has 60 days or 30 days to file their brief, which is called a response brief. And then you have like 15 days to file what's called a reply brief, where you reply to their response. And that's when the briefing starts. Enough is enough. But the reason that they do it that way is the appellant has to make the case for why the appeal is to appeal. And then each side should have one opportunity to reply.
All right. Makes sense. Thank you, sir. Man, I've been looking for this for like 10 minutes. For this one word. For this
Control F.
Control F.
What's up?
He's
like bullshitter. He's a bullshitter?
Yes.
Why do you say that?
Because he keeps saying the reasonable observer in context. It says like 100 times.
Yeah, what's wrong with that?
Well, he keeps talking about like I don't see a reasonable observer being in context.
In context.
You know what I mean? Because if you're in context, you're no longer objective. Like this paragraph.
Instead, the question is whether the reasonable or objective observer wanted plaintiff to describe their context and its place in an action landscape.
So I'm not sure that's his fault. That's the test. Maybe a dumb test.
But that's what I'm saying. Like the reasonable observer, knowing the context of the specific and deliberate location. But like, I feel like if you're informed, you're no longer.
You're no longer reasonable.
Yeah.
So that's the court is dumb. So because what the court has said is we want to know what an objective, like we want what a normal guy who knows the history would think. Now, what you're pointing out is obviously a normal guy would not know this. You're just like walking along and you see a monument. But the court says we don't care what a normal guy
Outside
thinks.
of the context.
We care what a normal guy who knows the history.
That's weird.
But no, it's like good for him.
Yeah, it
And
totally helps him.
He's explaining the rule in a way. He wants to make
Well,
sure
he-
the rule is explained in a way that's effective for him.
And it works.
He does have the authority. He does have the source.
I just thought that was like him saying something. I was like, that's
He's not just,
weird.
He's not just ripping there. Okay, let's chat. Let's chat about the what's he called? The killer, the Zodiac killer. Yeah, chat about the Zodiac killer.
Why
Okay.
is he calling this?
Emily, what did you all talk about?
We liked it. We thought she used the word punchy, which
Use the word what?
punchy.
I think that's a great word for it.
I found it like pretty humorous to read at some points.
Good. Give us some examples.
The one about the Sabbath day.
Yeah, that's my
the
favorite.
Football.
Where tell us what page so we can all be on the same.
Page 84 of the supplement.
Mhm.
And like so he says, remember the Sabbath day, keep it holy. For example, no one reads like the state has adopted a position on whether the Dallas Cowboys should continue playing professional football on Sundays or whether the Texas Longhorns should continue playing college football on Saturdays.
Yes, and he's even got this little parenthetical. Notwithstanding the seriousness and even religious fervor with which Texans approach their football, it would be a stretch to describe the game as holy. Humor is very rare in briefs and very risky, but he is not a risk-averse person by nature, and I think he pulls it off here. I agree with you on that. Good. Bryce, what writing principle did you think was illustrated or flowered?
I liked his bridging.
Good. There's some examples of that. Or an example
Like
of that.
page 72. He starts a paragraph. The second paragraph he starts with instead,
Yep.
which is weird.
Yep. What does instead? What purpose does it serve there? It bridges the previous paragraph. I just told you all that other stuff, but now instead I'm contrasting this with that. So good contrasting there. Sydney, what did you all think?
We liked where he did the bullet points.
Let's talk about that.
Saying that was wrong.
Yeah.
The other person.
So point us to what page that's on.
That might take one. Oh, 74.
Yep. So what's he doing here?
Showing how the other person's wrong.
Yes.
Being credit.
Now this is I love this part too. It's very aggressive. It's very this is like punchy on steroids. And again, it's like the humor. It's pretty rare. I mean, to usually one side writes a fact section and a brief, and then the other side writes their brief with a fact section. And of course, the fact sections emphasize different things, but it's very rare for the respondent's fact section to just go point by point, like you lied, here and there. And why is it rare? Well, for one thing, it can look obnoxious, but it can also look petty. If you're doing it just to make your opponent look bad, a court is not going to respond well to that. Court wants you to get to the point and explain what the law is and explain why you should win. They don't really care about petty sniping between attorneys. But I think he does have a bigger purpose here. I mean, I think that he is dealing with a legal question where the nitty-gritty specific facts are, for better or worse, extremely important. I mean, we might debate all day whether it should matter whether a nativity scene is accompanied by Santa Claus and the menorah. But the court has said, if it is, it's okay. If it's not, it's not okay. So the context of all these facts really do matter a lot. And so he thinks it's really important to paint a picture of the facts and the context and the specifics of this display in a way that's beneficial to him. My favorite part of this, the top of page 75 of the supplement, he had said on the previous page that the plaintiff, the petitioner, had asserted that the Ten Commandments is prominently displayed on the Great Walk. He says the monument is nowhere near the Great Walk. Instead, what petitioner describes as the Great Walk is in fact a driveway where Capitol staff park their cars. So I think it's a very effective section because the facts are so important to the legal outcome. So he is prioritizing, I think, the right thing, and he's doing it in a crystal clear way. Does it remind you of any other section of a brief we read this year?
That was last.
What'd you say?
So that was last year.
What'd you say?
I can't remember.
Someone from last year?
Yeah.
People do a lot last year. I can't remember it. Do you remember any of the specifics? That's all right. It reminded me of, remember Miguel Estrada, the first brief that we read this semester about the Brady case? And he's got a chart and on one side of the chart is everything Stolfus said at trial, and then on the other side of the chart is all the contradictory things Stolfus said when she talked to the police before trial, and that information had not been disclosed to the defense. Bullet points, charts, bless you, can be effective, especially in a situation. So I like that a lot. Zach, what did you think was done well or not as well?
He did really good rule explanation.
Good.
What
So
we were
point us
pointing
to
out,
where
it
he's doing that.
was page 71 of the supplement. Like when he's talking about the lemon test, he's like explaining how they like laid it out, and then why. The next paragraph he talks about why that was bad, and then I forget where it was. On the next page 73, he talks about like the difference between what the test shouldn't be and what the test should be.
Good. So I agree with Zach here. I actually have in my margins written right by that paragraph, since lemon, I have good rule explanation. So great minds think alike, but also so do ours. I do think it's good rule explanation. If you flip to the page before that, it's the summary of the argument. I think we haven't read a lot of summaries of the argument. So let me talk briefly about what function the summary of the argument serves, and then talk about why I think this is really well done. Your brief, and I think all good briefs, have an introduction section, and they have a summary of the argument section. And they are very similar. And students often think, well, are they identical? No, I don't think they're identical. So the very first section of your brief, before you do statement of jurisdiction, before you do facts section, whatever, is going to be the introduction. And that introduction is your chance to just tell a little facts and tell a little law and make your case. So imagine that you have 500 words to tell someone who knows nothing about your case, everything you want them to know in order for them to think you should win. By the time you get to your summary of the argument, you've already written a facts section. So there's no longer any need to summarize the facts. The facts have already been stated. So there'll be, I don't remember the exact order, but like introduction, statement of jurisdiction, statement of the issue, facts, summary of the argument. So by the time you get to that summary of the argument, you don't need to summarize the facts. The summary of the argument is an opportunity to kind of preview the argument section, almost point by point. So if your argument section has 15 paragraphs, your summary of the argument might have 15 sentences, each sentence summarizing a paragraph. Don't take that literally, don't literally do that. But my point is that the organizational choices you make for your argument section can be reflected in your summary of the argument. And it's a time to just summarize the argument, not worry about the facts. Okay, now, what does he do here? First of all, I think he uses his summary argument to make an elevator pitch, which is nice. He's got some key details in there that are going to be relevant to his argument. He's got a roadmap, and he's got a mini CREAC. So let's start on page 69 of the supplement. Start with the second paragraph there. Under Lynch and Allegheny, and here, Michaela, this question is coming to you. Under Lynch and Allegheny, the overall history, context, and surroundings are critical to determining a display's constitutionality. If aware of that full background history, the reasonable observer would not perceive the monument to be government endorsement of religion. The monument is constitutional. Okay, let's stop there. Do you think that's rule explanation or rule application?
Rule application?
Why do you say that?
Because he's talking specifically about the monument.
Well, I'm stopping before the last sentence of that paragraph. So up until then, he's talked about Lynch and Allegheny, and he's talked about, just in general terms, what the test is for this kind of constitutional claim. So I think it's going to be rule explanation. But I can see where once he does that last sentence, he talks about the Texas monument, he has begun to go into rule application. But let's look at the first two sentences again. Under Lynch and Allegheny, so he's talking about precedents without talking about the facts of our case. The overall history, context, and surroundings are critical to determining a display's constitutionality. That applies to any display, any religious display, not just this specific display. If, aware of that full background history, the reasonable observer would not perceive the monument to to be a government endorsement of religion, then the monument is constitutional. There, I think he's talking about any monument. He does say the monument, so I think that can be a little bit confusing. I think maybe he's talking about the Ten Commandments monument in Texas. But I think that he's talking about whatever the monument is that's in question, here's the rule for it. Here's the test for it. So I think he does some rule explanation there. And then, in that last sentence, he transitions to rule application. He says the Texas monument easily meets that standard. And actually, he could probably take that last sentence of the paragraph and make it the topic sentence of the next paragraph. And that way, you would have a paragraph on rule explanation, and then you would have a nice topic sentence with the bridge. What's the bridge? That standard. I just did rule explanation to explain that standard to you, and now that I've explained that standard to you, I'm going to apply it to the Texas monument, and the Texas monument easily meets that standard. And then this paragraph about the effect of the monument is merely a government acknowledgement that the Ten Commandments, the Western civilization, legal codes, et cetera, that's application. So I think that it does a nice job of having like a little preview of CREAC there. Bless you, kind of reflecting the structure of the argument section to come. But I also think that it's got a nice roadmap. And I would view some of the argument as that. It should be a roadmap to kind of like let the reader know, okay, we're going to travel along this road. It's a pretty long argument section. Here's a little preview of that road. Here's a roadmap. And then last thing I'll point out is sometimes precise details can really strengthen your argument. So last week, maybe it was the Carvin, so 2 classes ago, he had this statistic about like $1 trillion in government spending or something like that. Mm-hmm. And it was, I think what he was hoping is like that statistic would just like get stuck in a judge's mind, and the judge would be like, oh man, I'm very troubled by that statistic. And remember, I think I told you there was a statistic about plea bargaining that stuck in Justice Kennedy's mind one time. Did I tell this class that? No, anybody remember what it was? No, maybe I didn't. So there was a case about whether or not you have a constitutional right to an effective attorney if you're a criminal defendant at the plea bargaining stage, so before your trial begins. And it's really well established you have a constitutional right to an effective attorney at trial. If you don't, it violates your right to an attorney. But the precedent was also pretty clear that since you don't have a right to a plea bargain, you don't have a right to an effective attorney at the plea bargaining stage. In other words, why don't you have a right to a plea bargain? As you may know, it's like you're charged with murder, and the prosecution says, all right, if you plead guilty, we'll make you a bargain. We'll drop the murder charge, and we'll just charge you with manslaughter. You'll get 10 years instead of life. That's a plea bargain. And you don't have a right to that. It's not like the government has to offer you a deal. And so the precedent said you don't really have a right to an effective attorney at the plea bargaining stage. But there was one statistic that like got stuck in Justice Kennedy's mind and like made him think, I don't really care a whole lot about what the precedent says. There's no way I'm going to tell a criminal defendant you don't have a right to an effective attorney at the plea bargaining stage. Here was the statistic. What percentage of convictions do you think result from plea bargains?
90 or something?
80.
You're all in the ballpark. It's in the 95% ballpark. And it varies a little bit by states or federal. So Justice Kennedy hears that statistic, he's like, we can, if we follow precedent and kind of like, I would say, logic to a degree, it means that 95% of criminal defendants who go to prison are going to go to prison without ever having been guaranteed an effective attorney. And that just like can't happen. Like I don't want to live in a world where that happens. So we're gonna make the law say we want. So the statistic, right? Statistic 6 in his head. So I think that Cruz here, from the very beginning of the summary of the argument, is using some specific details to kind of just like plant in the reader's mind some facts that he thinks are going to be really good for him. So if you look at the first paragraph of the summary of the argument, page 69, here are the facts that I think are useful. 4 decades, 17 monuments, one of the smallest monuments, behind the Capitol, and 6 other monuments. So 4, 17, small, behind, and 6. What are these details he's pointing out? This statue has been there for 4 decades. Now, you might think, who cares? I kind of think, who cares? But the court has said that it really cares whether like the statue has been there a long time or whether it was just like put there yesterday. Think of it this way. If a city were to name itself San Francisco tomorrow, maybe, think of it this way. What if a public school were open tomorrow, here in Louisville, and it decided to name itself St. Francis Public School? Now, some people would be fine with that, but I think some of you would think, it kind of sounds like the government is endorsing religion there, and I have a problem with a public school named after St. Francis. So maybe a court would say that's unconstitutional. I suspect a court would probably say that's unconstitutional. But is there any chance that a court is going to declare the name of the city of San Francisco unconstitutional? No. I mean, maybe some of you would, but and you know, hats off. That's an aggressive approach to the Establishment Clause. But I would be willing to bet that no court is going to declare the name of the city of San Francisco unconstitutional, even though it's named after St. Francis. The court does seem to care about like how long something's been there. So 4 decades, 17 monuments. Again, this goes back to the creche next to the Santa Claus, next to the menorah. It matters to the court. There's all these non-religious monuments, and so the Ten Commandments is just like 1 of 17. Not that big a deal. Nothing to see here. It's small. Like it would matter to the court if it were like towering over everything else. But it's kind of like small. So the court seems to care about that. So he wants to make sure the court knows that fact. It's behind the Capitol again, just kind of out of the way, and it's surrounded by 6 other monuments. So it's not like it's like very prominent. So he's trying to paint a picture here of just, yes, it's the Ten Commandments, but it's not like, it's kind of like out of the way. It's kind of like not a big deal. Nothing to worry about here. Do you think it works? Who has the rest of the story today?
I do.
Yeah, did it work?
Yep. 5 to 4.
Yep, it worked 5 to 4. And I mean, I think that these little details he's throwing in there, 4 decades, 17 different monuments, surrounded by 6 other monuments, one of the smallest behind the Capitol, are what wins the case for him. Because on the same day that the court says this 10 Commandments is okay, did you see what happened with another 10 Commandments?
The other case? No.
Yeah, the other case, they said it's not okay. The very same day the court said the 10 Commandments is okay on government property in Texas, it said it's not okay on government property in Kentucky. And so, same 10 Commandments, it's not, same, talking about well-established, like that's, same 10 Commandments, but what made it different was that the Kentucky 10 Commandments hadn't been there for 4 decades, wasn't amidst 17 other different monuments, wasn't the smallest monument among them, wasn't kind of tucked behind the Capitol. What does he say? Basically like in the parking lot of where the staff parks, something like that. And it wasn't surrounded by 6 other monuments. So these facts that he is, I think, clever enough to emphasize right there, first paragraph, so you can't miss it, are the facts that I think help him win the case. Okay, good. All right, any other thoughts? Yeah, I was going to call on you next anyway. So.
On page 17 of the brief, where he like adds in the links to the photo, is that a good tactic, or is that something normally done?
Let's see where we are. So he says the entire grounds are meticulously maintained and clearly set apart from the surrounding city, and he's got a link to the photo there. I don't think that's a bad thing. I mean, if he thinks it's important, at least put the support for that. If he thought it was really, really important, I'd put a picture in there. You don't want to overplay that hand, and the court starts to think that like you're treating them like children. But I put a picture in a bench memo once. Like I really, really wanted my audience to see it, so there it was. And I think people can disagree. I think that there was a co-clerk who was like, "Gosh, you're like treating Justice Kennedy like a child." But I wanted him to get the point, and I wanted to make sure he couldn't miss it. But I think at the very least, if you're going to refer to something like that, back it up and support it. Because know your audience. This audience probably hasn't been to Austin. Not all 9 of them.
Are we going to listen to them?
He didn't do this argument, and so let's see if you can figure out why. He was the Solicitor General of Texas. This is a very popular position that he's taking in Texas, and it's a Supreme Court argument, so there's like a certain prestige that would come with doing that. I dreamed last night. Normally I would not like share dreams with class, but this is pretty. That I had my first Supreme Court argument, and there was no microphone, So I had to yell it. I was screaming my whole argument.
Pretty cool.
So in reality, the justices are like about as close as like Shelby and I are right now. But in my dream, they were far away to yell. So in any event, how do we even get on that? What did you ask? The oral argument. The oral argument. So why do you think that he didn't get to do the oral argument?
What, this was in 2005? Right?
Yeah, and he was Solicitor General of Texas at the time.
He's gonna run to be senator?
Yeah, but it would have been great for him because Texas loves the Ten Commandments. So I mean, not everyone, but he has a boss. Who's his boss? The Attorney General. Yeah. So it goes. The Attorney General hires the Solicitor General, and usually the Solicitor General does the argument, but popular position, high profile. The Attorney General was like, I'll take this one myself. And the Attorney General then ran for governor, and he wanted to use it for his own thing. So he did the argument. So we can't listen to Ted Cruz do this argument, but we are going to listen to the best oral advocate of his generation do an argument in this case. His name is Paul Clement. So we'll do that in a minute. I think we'll do it now. Any other thoughts on this? Actually, there were some things. None one's criticized it at all. I mean, yeah.
Sorry, I didn't mean to interrupt.
No, good. I want to talk more about it.
Why, okay, hang on, I lost the page. Page 77,
Yeah.
the supplement. His, the section headings are tabbed over, and it looks really
Oh,
weird.
yeah.
But, I kind of see that maybe it's done that way, so it kind of looks like an outline in the headings, but that seems confusing.
It looked weird.
It does to me.
Well, it's to each your own thing. I would recommend doing it. You can see I kind of actually did it just I have it here. Because I think it helps the reader know that this is a subdivision of this, and this is a subdivision of that. Yes, the reader can know that if they're memorizing that okay, this is 3, and the last thing you did before these Arabic numerals was a capital letter. But if they haven't memorized all that, and you can also see, I wouldn't recommend going any more over than that, but capital Roman numeral, capital letter, Arabic numeral, lowercase letter, and then lowercase Roman numeral is how I would.
So just the heading is indented?
Yeah.
Not, okay.
Yeah. Let's see. What I did have other things. So here, we have a little extra time today. Yeah, Dimitri.
He almost got out with any bad things said about it.
Yeah,
but
no, I was going to say some bad things, but you go first.
He said petitioner a lot, but you don't like us to use that, right?
No, I don't. It's a little bit more acceptable, I think, when the petitioner is not part of the story.
Oh, okay.
So, this is all about whether the Ten Commandments are constitutional or not. The petitioner is just like a vehicle for challenging. It's not like the petitioner was part of a tort claim where Bob walked into Walmart and Bob slipped and fell and whatever. So I think it's a little bit more acceptable here, but I still don't like it. I mean, who is it? I think it's Van Orden is the plaintiff. So I would almost always err on the side of saying Van Orden. So, and definitely in a criminal case like ours with the confrontation clause, Miller is obviously a player in the story. So I think it's better. I definitely think it's better to say Miller and not defendant. Yeah.
Just an observation while I was reading it, I think I counted them over 20 times where he said reasonable observer or observe reasonably.
Yep. And why do you think that he made that choice about repetition?
That was the test. That was his point. His theme.
Yep. I think that was part of the theme. It doesn't really matter that Van Orden was offended. The court's rule suggests that we don't care about Van Orden, and the court's rule suggests we don't care about Jerry Falwell. The court's rule is we care about the normal, average, Joe, who sees this, but as we were talking about, who sees this and knows the whole history of it. It's kind of like a fiction, but that does seem to be the court's test, so he goes along with that. What do you think of the, speaking of kind of like the petitioner phrase, he uses the term decalogue a lot, which maybe you all have heard that word. I'd never even heard that word before as a substitute for. You looked it up. It means Ten Commandments, right? Or like,
Yeah, I was like, I looked it up and was like, oh, Deca.
yeah. Why do you think he says decalogue instead of Ten Commandments? I think he has a reason, but I don't think it's a good one.
To make it seem more secular.
Yeah, I think so. I think he thinks the decalogue will sound
Not like the
more,
Ten Commandments.
sounds Greek, you know, and not Judeo-Christian. But I think it's just confusing, and he's just say Ten Commandments. If you're too afraid to say the word of what you're defending, maybe you shouldn't be defending it. So, and I don't think he is. I mean, too afraid to say it. I think he just thinks that it's a better strategy, but it's bad. Well, the one thing that topic comes up in is in obscenity cases, where like Cher blurts out the F word during the Oscars or something, and then like people get fined, and then you challenge it as First Amendment violation or whatever. And like, when you're in your fact section, do you actually use the words that she said? Different attorneys take different positions. But I think if you're going to defend it, you ought to be able to say it. So let's see, what else did I not like here? I thought that there was a lot of repetition, not just with the reasonable observer, but maybe too much. But I tend to, sometimes it's not, it might maybe too much. It was very argumentative, and at times, like, I think bordering on obnoxious. And of course, that's his MO. But I don't think he crosses the line. But to have a whole section on the description of facts that we're talking about, that is very argumentative. Let's see, supplement page 76. Let's see what's on there. He, the petitioner, postulates a large, uniquely religious monument in front of the Capitol of the Great Walk, situated by itself, so that no other monuments visible standing before it. That monument does not exist, at least not in the state of Texas. And so his lengthy exegesis as to blah 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 has little bearing on this court's inherently fact. I think it's pretty argumentative there in the paragraph before that. Indeed, his entire legal argument. Indeed, by the way, is a Ted Cruz trademark word. It's like every other word out of his mouth. Indeed, his entire legal argument is explicitly predicated upon a series of false premises without which it cannot survive. I think it's good. I think it's punchy, as Emily's that was the word he used. I think it's punchy, and without being too obnoxious. But some people might find it that way. He's got some analogies. He's like analogizes to this whole thing as a museum. I think sometimes the analogies are a stretch. The analogy to money, he's like, we say in God we trust in our money, so why is it different to have the first commandment, the Ten Commandment displayed? Well, it is actually like kind of a pretty big difference. Like, one says in God we trust, and one says I am the Lord thy God. Like, I think it's a stretch. But no, good. One last thing to think about. We talked when I was first describing the difference between trials and appeals. Appeals are not times to litigate what the facts are. But I also said, or let me ask you, do the facts matter on appeal? Do the facts matter? Yes, Kelsey, why do they matter?
Because they can help you distinguish your case.
Yeah, exactly. Let's say we all agree on what the law is. We still might disagree on, whether how that law should be applied to our facts. And in your confrontation clause case, the facts are huge in this. Was the autopsy signed or not? Is the medical examiner part of law enforcement in the state of Brandeis or not? Any number of facts can be relevant, and so he does not. He has a lot of familiarity with the record. If you look on page 81 of the supplement. He's pretty, here the Ten Commandments monument sits on the Capitol grounds in a line between the Capitol and the Supreme Court. Actually, just even throughout the whole thing, throughout the whole brief, there's facts everywhere, and it's familiarity with the record. So I do think that when you think about what kind of research you need to do before you start writing your argument section, yes, you need to research precedents, but you also need to be really familiar with our record in the same way that he is. All right, any other questions? Yeah, Dimitri.
What would Van Orden get besides like the 10 Commandments being gone? Just that's it.
Probably attorney fees, which they're not going to help Van Orden.
So
but,
these three.
Yeah, no, he doesn't stand to gain a whole lot. I
was just wondering.
I'm sure he cares.
Yeah.
But I don't see any money damages.
So he's just got a lot of time to take this.
I mean, probably the ACLU went and found Van Orden and was like, "Can we sue on your behalf?" But not necessarily. There's a guy named Newdow who's a very passionate atheist and has brought a lot of suits along these lines. And I think he does often represent himself. And so, he's had mixed success. Actually, he's had no success. But,
tough for him.
But he's... All right. Any other thoughts? Okay, good. So let's... we don't even vote on Cruz today. We got to read Obama first. So let's listen to the oral argument. Okay, so what happens in this case is that Van Orden sues the state of Texas, says you're violating the First Amendment. Anytime that the United States government wants to file an amicus brief, they do that, and the court will always accept that. And unlike most amicus briefs, we talk about amicus briefs already this year, I think.
Yes.
Right? Yeah. Unlike most people, friend of the court. Unlike most people who file amicus briefs, the court usually gives the United States oral argument time after they file an amicus brief. So in this case, the United States filed a brief in support of Texas, and so instead of giving Texas 30 minutes of oral argument time, the court probably gave Texas 20 minutes, and it gave the United States 10 of those 10 minutes. And so the attorney for the United States was the Solicitor General Paul Clement, who's now in private practice, and is I think, and it might not come across in just a 3-minute clip, I think he's probably the best oral advocate in the country, and he's definitely the most sought after appellate attorney in the country. The year I was clerking, he did. Most attorneys will go their life without doing a Supreme Court argument. The 50 or so top Supreme Court advocates are lucky to do one argument a year. And then if they have a 30-year career, they've done 30 arguments. That's quite a record, quite a resume. That would be one argument a year. The year I was clerking, Clement did 11 arguments in just that 1 year. So he's very sought after. Okay, so let's listen to what he has to say here.
What's he get paid an hour?
What'd you say?
What's he get paid an hour?
He's probably the 2,000 range an hour.
I have about the government's position. And does place matter at all? I mean, here we're talking about the grounds surrounding a state capitol. What about every schoolroom, if that's the choice of the school board? Is it the same, or do you make, or every courtroom up to the court to decide for itself?
Well, Justice Ginsburg, I certainly think location and context matters. I think in almost every Establishment Clause context, the setting and context matters a great deal. The school case, for example, as you suggest, unless this court is going to revisit Stone against Graham, it's certainly true that the school context at least raises much more difficult questions. In terms of where it can be displayed in a courthouse, I think there are certainly permissible displays in the courthouse, but it may be something altogether different to have a display in a way that it actually looks like a religious sanctuary within the walls of the courthouse.
It looks just like this monument. Let's take this monument and put it in the rotunda of the court, because the judges of that court choose to have it there. Is that all right?
Justice Ginsburg, I think putting it in the rotunda of the court as a standalone monument, giving it sort of pride of place, if you will, raises a much more difficult question, to be sure, and may well cross the constitutional line. As I was alluding to, the one case I'm familiar with, which is the case of the Alabama Supreme Court, there it was displayed in a way that the district court literally found it was like a religious sanctuary within the walls of the court.
And do you think that should cross the constitutional line under the interpretational theory of the First Amendment you wish us to adopt?
Well, I think the display that I have in mind in the Alabama Supreme Court probably does cross the constitutional line, even under our view. I think that a display of the Ten Commandments in some appropriate way in the courthouse certainly wouldn't cross the line that we would have this court draw. I mean, we think, for example, it cannot be that the very fact that moving it closer to the courthouse itself is a constitutional problem. Because as you yourself have pointed out, Justice Kennedy, the legislative prayers that were approved in Marsh v. Chambers were at the absolute epicenter of the government, and still those were a permissible acknowledgement of religion. So I think while context matters, I don't think solely the fact that it's moved closer to the seat of government does have a dispositive impact.
Okay, so we'll stop there. Talk to the person next to you for a couple minutes, things you think you did well or things you think you could improve on, and then we'll share.
He didn't really dance around the questions either. Talk right to him.
What did you think?
Yeah,
he's a beast. One sentence. He liked your Jordan. I do.
You what?
I like the Jordan.
Oh, thank you. Thank you. Have y'all already talked about your oral argument?
So the research assistant in this class in the magic.
Yeah, teaches the magic group.
Yeah, Zach.
We did them last year. I
Did
had
you
classes
sing
with
and
him.
stuff?
Oh God, no.
He sang and he did a magic group.
He was a theater major.
Do you have any other talents besides research abilities?
She's cool.
I can edit your paper. No, I don't.
Not even cool?
She's gotta get.
He said she was cool.
Oh yeah, that's a talent to
Yeah,
me.
that's a vegan.
No.
Zach's not
You can
vegan.
like bring in meat and then
Stop, Dimitri.
I should think. He's really good. Like he's like that magic trick was like a show.
You should see him at trivia. At the end of the year, I think it's the last class, you play like a trivia game, and like half of it's about like the actual stuff in the class, and then half of it is there were things that you're like, what is your talent? I was like,
Great
I
question.
don't have one.
What are you gonna do
Like,
for
can
us?
you sing? I'm like, no. No fair.
That's all right.
It was a theater.
Emily's a better RA than Zach. Just kidding. They're both great.
I like you today.
Okay. Michaela and Taylor, tell us what you were talking about. What do you think you did well?
I think that he was very calm. It was like a conversation. Like he already knew what he wanted to talk about, and I think he was actually listening to the questions, and he wasn't really nervous or anything. It was just like, hey, I'm here. Let me tell you my argument.
I think that's perfect. Michaela packed a lot of great lawyering skills tips into that. Number one is listen. Listen to the question. I've talked about this before. But it's so easy to not do that in an oral argument because you're always, you're nervous. You're thinking about, okay, what's the next thing I'm going to say? What's the next thing I'm going to say? And you're planning ahead. And when you're doing that, the temptation is to not listen to what the questioner is asking. So he listens. And then you also pointed out that he's calm. And his tone is, I think, kind of like almost soothing and conversational. Mm-hmm. He's not like overly casual. He's not like insulting the justice, but like, hey bro, right? But he just like, everything about him exudes competence and calm and ease. And so I think that his unspoken message in every oral argument is to the justice, like, it's easy to follow me. It's easy to do what I want you to do. You don't have to make a lot of logical leaps. You don't have to throw out everything you believed before I started talking. Like, whatever you believe, let's just like go with that, and it will all lead us to the right place. And I just think it's a great tone. But the tone alone wouldn't be good. The substance weren't good. But he's super prepared. He knows Stone. He knows the precedents. He knows his Alabama hypothetical. And then what kind of question does he get, Kelsey?
Like a slippery slope.
Yes, he gets a slippery slope question. Those are dangerous. because if you concede too much on a slippery slope question, then you look extreme. It's like, hey, isn't it true that like if you're right, then this other thing is also right? And this other thing might be like, you know, the apocalypse. So we don't want that slippery slope. But then you also, you know, if you resist it too much and you're like, oh no, like the apocalypse is bad, but you don't have a reason, you don't have a way to distinguish your case from that bad, you know, end of the slippery slope. Then you look unprincipled, and it looks like your logic is bad. So you either look extreme and dangerous, or you look illogical. That's the danger of a slippery slope question. And he doesn't do either. He definitely doesn't concede the extreme. You know, his message here is like, I'm sure there are people on this court, he's sure, I'm sure, that are fine with like building a gigantic 10 Commandments in the steps of the courthouse and like renaming the courthouse like God's temple. Like Scalia would have been fine with that, and Thomas would be fine with that. But he needs more votes than them, and so he's saying even if you're not fine with that, you can still be fine with this 10 Commandments in Texas. And he doesn't just say there's a difference, like that poor guy from the Department of Justice did in the DC Circuit when he kept getting asked the same question and just said those cases are different, but he didn't have a reason why. Clement is able to explain why this case is different than that case. So I think he does a nice job there. Other thoughts? He did well. He's already feeling better. Yeah, Sharia.
He spoke fast and he didn't pause or stutter at all.
Yeah, I agree. And I think Mikel and Taylor were talking about that too. You know, I mean, some people just can't help, you know, their stutter. So it's some of this is not just his preparation and choices he makes during the argument. Some of it's just like natural born talent. But he's easy to listen to. It's like good. Let's see. Do I have any other thoughts on him? Conversational. He's patient. He's not loud. He's not abrasive. Doesn't take extreme positions. Doesn't back down on necessary positions. Oh, note that when he mentions precedents, he didn't do it so much with Stone v. Graham, but he does it after that. He subtly reminds the justices about what the case was about. And this is a curse of knowledge thing that he's aware of. Judges tend to remember case names much less well than they remember like the legal principle that arose from that case. And so he doesn't just assume that they know the names of all these cases. He reminds them what they're about. So all these things are things that you should keep in mind anytime you address a judge for an argument. Pre-trial, during trial, you know, you're trying and the opponent in the middle of the trial says, "Objection, Your Honor," and then you like have to like respond to that objection and try to get the judge to overrule that objection. Be conversational without being too casual. Be patient. Don't be loud. Don't be abrasive. Don't take extreme positions. Don't back down on necessary positions. And to the extent you're using precedent to support what you're saying, don't just use the case names. Remind the judge what that case stands for. Should we vote? Do we have any votes?
We don't have
any
votes.
So sad. So sad. I thought about I'm not going to do this, but like giving you time to read the Obama brief instead of doing it for homework, and then we could vote today. But I'd rather you all be able to take your time with the Obama brief. And besides, I forgot to do stuff about research that I was going to do. But we can't do the rest of the story though. What's the rest? You said he won. Anything else we should know?
Well, the Van Orden guy, the reason why he had so much time on his hands is because he was a homeless person with
Really?
a suspended law license.
Okay.
Wow.
So, I guess he was under hard times or maybe a little nuts. But I think James mentioned it a little bit, but it was established in, the monument itself was from 61, and the Fraternal Order of Eagles, like a really multi-denominational kind of service organization. So I thought that's a point he made that was really well done there, where he kind of gave the history of the organization to help his argument. And the Supreme Court, I guess their primary justification for the ruling was that it was historical, not religious, just as Cruz had argued. So, yeah.
Great job on the rest of the story, Sam. Okay, did not realize who Van Orden was. Interesting. And actually, I didn't know the history of the Fraternal Order of Eagles either. There is a Ten Commandments displayed in the Supreme Court's courtroom. So, you know, take that for whatever it's worth. But so there's also nude figures displayed in the Supreme Court's courtroom. So again, on that obscenity trial where the attorney decided to use the F word when necessary in describing the facts of the case, he also pointed out, like, let's not get too worried about some like fleeting, obscenities here. Like, if you look around, like, even the court is like okay with nudity every now and then. So, okay. So we will prep for the Obama brief, and we will talk about some research things. Let's do the research things first. So on Wednesday, by then everyone will have done their research meetings with me. Actually, by the end of today, everyone will have done their research meetings with me. And they've been going well. People have done a nice job in terms of at least the beginning of their research. And I want to give you all, I think it's important for you all to learn how to do research through experience and trial and error before I just like tell you, too much before I like do it for you. And so I think it's been good. I'm glad we've done it this way. But on Wednesday, I will give a lot more guidance on the substance and to some degree the organization for the briefs. And someone asked me a great question in one of the meetings, said, when should I start drafting my argument section? And it's fine to start drafting now if you want, but I would say after Wednesday, like I think after we have class on Wednesday, I think you'll be in a good position through your own research and then through what we talk about then to start drafting. And of course you have Friday off from this class, so you can use that time to draft. And so that draft of the argument section every year comes faster than students expect. So I mean, it's been on the syllabus since day one, but it sneaks up on you. So I would encourage you to start drafting your argument section on Wednesday after class. Okay, but there's three things I want to talk about related to the research before then. One is a couple of students were somewhat confused about the line in Crawford and subsequent cases about an opportunity to cross-examine. It's not something that you really need to prove in your argument section. Well, here's the way it works. The defense has a right to cross-examine, has a right to confront witnesses against him. Now, there's an exception, and the exception is if the witness is truly unavailable and there was an opportunity to cross-examine the witness. But don't think that it was the defense's job to create that opportunity. That's where a couple students have gotten confused. The exception to the confrontation clause is if the witness is now truly unavailable and the government made the witness available for cross-examination at some point. So for example, let's say there was a pretrial hearing and the government called the witness and the witness testified and the defense had an opportunity to cross-examine the witness at the pretrial hearing. And then now the trial is a year later and the witness is unavailable. Okay, well then the court would say no confrontation clause violation because the witness is unavailable and the defense already had an opportunity to cross-examine. But know that it was the government that created that opportunity for the defense to do the cross-examination. It's not like the defense has to go track down this witness and cross-examine him, and if they don't, then they've lost their confrontation clause. That's not the way at all. Not the way it is at all. And also don't think of unavailable as like necessarily like impossibly unavailable. Just like actually, you don't have to get into that because I'm telling you, the defense did not have an opportunity to cross-examine Dr. Hines. Okay, so the only question remaining is whether or not this stuff was testimonial, whether the autopsy report is testimonial, and whether or not Dr. Adler's testimony was in violation of the confrontation clause because she was incorporating into her testimony testimonial statements. By the way, it is there's something like mildly confusing about the terminology for this case. We talk about rule explanation, where it's like, what's the test? What's the legal rule? So, for example, like the Brady rule, we talk about the Brady test, 3 parts of the Brady test. So like test is kind of interchangeable with legal rule. On top of that, in our case, or in some of the precedents, like there was a cocaine test or there was a DNA test that was done. So we might say, what is the test for whether that test was okay? What is the legal test for whether that medical test was okay? And then to confuse it even more, we talk about testimony and we use the adjective testimonial. So what we're talking about in something like Melendez-Diaz is, we could say, what's the legal rule for whether or not the cocaine analysis was the equivalent of testimony? That kind of makes sense when we say it like that. But another way to say that exact same thing is, what's the test for whether the cocaine test was testimonial? And it's like easy to get confused. So don't confuse those 3 words: test, and testimony. You can, just in your own head, don't confuse it. Okay, so that's one clarification I wanted to make. The only thing we need to write about is what is testimonial and what is not. The second thing is harmless error, which has thrown off some students. I think I mentioned when I introduced the assignment that you don't need to write about harmless error for the sake of our case. But what a lot of students have discovered is that, of course, a lot of precedents do include a harmless error analysis. So let's talk for 2 minutes about what harmless error means in this context, and then it'll be more obvious why you can ignore it, but why you shouldn't confuse it with the merits. So anytime a criminal defendant appeals a conviction, the criminal defendant tries to point to some error that happened at trial. Maybe it was a violation of the rules of criminal procedure. Maybe it was a violation of the rules of evidence. Maybe it was a violation of the United States Constitution. Maybe it was a violation of the state constitution. Whatever it is, they say there was some error at trial. And because there was an error at trial, I deserve a new trial. Now, what the court does with that is the court first tries to figure out whether there was an error at trial. And that analysis is, I'm going to call it a merits analysis. On the merits, was there an error at trial? Was the Constitution violated? But often, even if the Constitution was violated, or even if the rules of evidence were violated, or even if the rules of criminal procedure were violated, the error did not affect the verdict. In fact, a case can be made that the majority of trials have some error, because, judges screw up. But many, many times, the error does not affect the verdict. And when that's the case, the appellate court calls that harmless error. And my point to you is, these are 2 distinct analyses. There's the analysis of whether or not there was an error. And if there was an error, there's a subsequent analysis of whether or not the error was harmless. You do not have to brief the question of whether the error in our case was harmless. In fact, you should not brief it. When you're reading precedents, do pay attention to when the court is analyzing whether there was an error at trial. And you can use that analysis to your advantage, regardless of whether the court later found that that error was harmless. Because whether the court found that error was harmless or not, it depends on all the other stuff involved in that old trial. And we don't care about any of that other stuff. It's unique to that trial. But the question of whether there was a confrontation clause violation, whether that error existed, is very instructive to us, regardless of whether or not that error turned out to be harmless for that specific trial. So let's say, for example, there's a precedent where the defendant ultimately loses the appeal. The defendant claims there was a confrontation clause violation, and the court agrees, but the court later concludes that that confrontation clause violation was harmless. That's bad for that defendant, but that's great for Miller, because Miller can still use that precedent to show what a confrontation clause violation looks like. And that's what Miller's trying to do in our case. Okay? Everybody on the same page now? Okay. The last thing is, what's a plurality opinion? And I love this assignment for lots of reasons, even more than I did when I first found it. And one of the reasons I love it is because it's a great introduction in your 1L year to what a plurality opinion is, which I taught a 3L class when I was an adjunct about 5 years ago. And many 3Ls in their last semester had never heard of the plurality opinion, still don't know what a plurality opinion is. It's really important to know because it makes a really big difference in terms of whether the precedent is binding or not. Okay, so here's what plurality opinions do. Did you learn about plurality opinions last year? In my class or someone else's class?
You.
Yeah, exactly. Okay. Plurality opinions are kind of like arithmetic. Okay? It doesn't matter how many justices are on a court or how many judges are on a court. I think our Supreme Court in Kentucky has 7, the U.S. Supreme Court has 9, federal appellate courts have 3. Whatever it is always an odd number. And to form a majority, you then need a majority of the odd number. So let's take 9 from the Supreme Court. Lots of opinions are 9-0, and then whatever the court says, that's the law. Some opinions are 8-1. Whatever the 8 say in their majority opinion, that's the law. Well, some opinions are 5-4, very closely divided cases. In that case, once again, whatever the majority says in that 5-4 opinion is the law. But sometimes, and Williams v. Illinois is a case like this, it's 5-4 on the outcome. In Williams, 5 justices say Illinois wins. But that sentence, which I'm paraphrasing, but that sentence is the only sentence that 5 justices agree on. Because four justices think Illinois wins because of X and Y and Z reasons. 1 justice thinks Illinois wins because of A, B, and C reasons. And these justices think Illinois loses. So what does this mean? Well, first of all, it means Illinois wins. And secondly, it means that if the exact same fact pattern were to come along, then this sentence, Illinois wins, would control the future case. But of course, the exact same fact pattern will rarely come along. And so, when a similar fact pattern comes along, the attorneys have to figure out how to use Williams v. Illinois. And here's where the plurality, this by the way is called the plurality opinion. It's of the majority. Of the majority, it's the opinion that got the most votes. This is the plurality opinion, and this is the concurring opinion. So, all the stuff that these 4 justices say in Williams v. Illinois, it's an opinion written by Justice Alito. It's not binding precedent. All of the sentences in Justice Alito's opinion, they are not binding precedent. Likewise, Justice Thomas writes this concurrence. All of his sentences are not binding precedent. And of course, the dissent, all of the dissent sentences are not binding precedent. The dissent is never binding precedent. So, what to make of Williams? Well, not nothing. All the stuff that the plurality says, you know, if you are a lower court, you're going to need to pay attention to that. And you're going to be very cautious about defying it. Because, you know, if the Supreme Court were to then take up your case, there's a pretty good chance the plurality would say what it said before, the concurrence would say what it said before, and if you disagree with that plurality, you lose. Lower court judges don't like to lose when their cases get taken up on appeal. But it also makes this concurring opinion a lot more important than most concurring opinions are. Let's imagine that there's a 7-2 opinion, and of these 7 justices, one of them writes a separate concurring opinion. So there's a majority opinion with 6 votes, and there's a concurring opinion with 1 vote. We don't really care what this concurring justice said, because these 6 didn't need that justice's vote to get their majority. They had a majority without it. This concurrence can say whatever it wants. What these 6 wrote is the law. But in this, you only got to the majority. You only got to 5 on the outcome because of what Justice Thomas said in his concurrence. And by the way, what does Justice Thomas say in his concurrence? He says he cares about whether or not an out-of-court statement is formal or not. So there's this whole primary purpose test that everybody's fighting about. Thomas doesn't even care that much about that. He cares about whether or not an out-of-court statement has indicators of formality to it. And the more formal, the more testimonial. So when you are writing your rule explanation, we'll talk about this next class, the main test that you want to explain in CREAC is the primary purpose test. Explain it and apply it. But then, because we do have to actually care about what Justice Thomas said, we only have to care because there were only 4 votes in the plurality. We're then going to explain Thomas's weird indicators of formality test. And we're also going to apply that test. And we're going to tell the reader the primary purpose test is the main test, but the formality test is also instructive. We would not do that if this plurality opinion with 4 votes had actually been a majority opinion with 5 votes. Does that make sense how it works?
You want us to say we wouldn't do it because we wouldn't do it if it was like 6-1 or 6 to.
I mean, you don't need to say that in your brief.
Oh, okay.
Because that's a know your audience thing. Your audience is expected to know how plurality opinions work.
I'm not.
But I think it's fine to point out that the lead opinion in Williams was merely a plurality opinion.
So anytime there's a concurrence, that could be plurality?
99 times out of 100, when there's a concurrence, it's this situation where whoever wrote the concurrence, either their vote isn't necessary and so we don't care about it, or they join the majority opinion. You see this a lot. So the majority opinion here would have 7 votes, including the concurring justice, but then the concurring justice would also be like, I join everything the majority said, it has my vote, but I also want to say this other stuff. There again, that's not that important to concurrence. But anytime that there's not a full majority opinion, there will be a concurring opinion. And I think actually that was probably what your question was. So if you have a court, let's say the state Supreme Court in Kentucky, 7 justices. If 3 justices think the defendant wins because of X, and 3 justices think that the plaintiff wins because of Y, and this justice doesn't agree with X and doesn't agree with Y, but thinks the defendant wins based on Z, this is the plurality, this is the concurrence, this is the dissent. Does that answer your question? Okay. Any other questions? Okay, so we don't have time to prep Obama, which is totally fine because I've got an email to send out to you anyway. That we'll have a full preparation for it. See you on Wednesday.